I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. Now we'll get started. Welcome to the third hearing of the Committee's inquiry into identity protections for proceedings involving children. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures in connection to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Robert Borsak and I am the Chair of the Committee. I ask everyone in the room, please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence given today. However, it does not apply to what witnesses say outside of the hearing. I urge our witness to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Right. You've done the oath and affirmation, blah, blah, blah. Okay. Would you like to make any sort of opening statement?
No, thank you. I'm in your hands.
Okay. Questions?
Do you want to go first, Susan?
Yeah, sure. Yeah. Thank you very much for being here. Just really a couple of questions. As you know, we're inquiring into identity protection of children, and you've done, as far as we're aware, one of the very few recent inquiries into a possible breach of the legal provisions in relation to that. And really just interested if you could tell us how that matter was reported to you, why it came to, I suppose, you in particular, what area of the police handled that, and if you could give us an overview of the steps that you took to initiate the investigation.
Certainly, thank you. Well, in terms of how the investigation arrived at, New South Wales Police was made aware, obviously we have a relationship with the Sheriff, the New South Wales Police, the New South Wales Sheriff. I was looking at another matter with the Sheriff, and I think a particular a judicial officer had a conversation with the Sheriff, and my details were exchanged given the nature of my work with the Cybercrime Squad, and then I went and spoke to the judicial officer in question, and was given an outline. As a consequence of that, all matters that are investigated at the State Crime Command need to be approved. I applied based on the information I'd been given to commence a criminal investigation. That was approved by the State Crime Command directors. As a consequence of that, that was then allocated to the Cybercrime Squad. In terms of why it was allocated to the State Crime Command and the Cybercrime Squad, it's a unique investigation. You pointed out initially that it's not a common matter that the New South Wales Police investigate. The crime squads have a little bit more time and expertise in terms of being able to investigate these matters at state crime. Not to say that PACs and PDs do not have that capability. Absolutely they do. So there's some brilliant investigators there, but it just rested with us at that particular time. And in terms of deciding which squad would investigate it, it was a bit of a grey area. It wasn't clear, but it probably lends itself more to the charter of the Cybercrime Squad because of the way, what we investigate, the electronics that may be used. So that's where the decision was made that it would sit with the Cybercrime Squad.
And the crime in particular that you were investigating, whether that had occurred, was that a particular section of the Crimes Act, or what was the offence you were looking at?
So initially there was three particular offences. So if we look at the Children and Criminal Procedure Act, so there was a breach of that. There was also a breach of the Crimes Act, which relates to 308H, where unlawful access. And then we were also looking at section of the Privacy and Personal Information Protection Act, Section 62. So
you did look at Section 62 of that legislation?
We did.
Okay. And how did you determine where to start? Who was the first person you interviewed?
So initially, if just for clarity, I'm the commander. So unfortunately, I have investigators a sergeant who the investigation was allocated to a sergeant, Detective
Yes.
Sergeant Julian Thornton.
Mm-hmm.
He's a team leader at the Cybercrime Squad. He has a team under him, a number of detective senior constables, and it was Julian's investigation in its entirety. So in terms of the investigative decisions making as the commander, I don't really get involved in the day-to-day activity, but I certainly oversight all aspects of it, particularly when critical decisions need to be made. But I guess you just follow the evidence. So the first thing was a statement was obtained from the judicial officer in question. From there, we moved on to considering, well, when you look at those particular offences, where are the likely where's the evidence likely to come from? So then you start to formulate a plan based on, well, what information do we need to gather, who has that information, and how are we then going to obtain that. From there you then make a number of decisions, because that really branches out. You look at potential witnesses, where are they? You start to send emails, make approaches to get statements, things like that.
And did everybody you approached for information or evidence, did everybody respond to your request positively?
Well, yes, but there are some people who provided information but did not provide a statement. But
Sorry, what's the difference between information and a statement?
They may verbally provide us with an account or what information they have, but they just don't provide a formal signed statement that's suitable for court, which is really, that's the end goal, that's what we're after. But that's not unusual. Being at State Crime Command just this week, we're dealing with people who would like to provide information but don't want to provide a statement. And I think policing is the only profession where you can be made to provide a statement for court. So we ask, and certainly we try and encourage people to provide statements, but they're not obliged to, so that's a matter for them. And some people sought legal advice as well, which is, once again, pretty standard.
So in this investigation, who were the people who provided information but not statements?
There were, in terms of names, I could probably, if I can just refer to some of the notes.
Yeah, of course, please do.
Excuse me. So one of the first people that we approached was the New South Wales Shadow Attorney, Mr. Henskins. So we did speak to him, and he did provide us with information that was relevant.
Yes.
We requested a statement, but that individual chose to decline that request, but did cooperate and answered our questions and responded as we. As per the investigation and our outcomes. There were others that we wanted to offer. We requested statements from.
So Mr. Henskins provided information, not statements. Anybody else that you asked for who provided information and not statements?
I can take that on notice. I don't believe so.
Could you?
I don't believe so, but
Okay.
I think everybody else, where we did, some people provided statements, and as I said, others where we requested statements,
yes,
but they didn't provide them.
Okay, so from whom did you request statements and they declined to provide them?
So Sally Dowling from the DPP. So that was one of the people we were keen to speak to and obtain a witness statement.
Yes. And did she provide information, or she declined to engage with your questions entirely?
No, not declined. So we were dealing with, at the time we approached the DPP for information, we were allocated a particular person to deal with.
And who was that?
That was Craig Highland.
Yes.
So he was a senior solicitor at the DPP. We would then outline what it was that we were after, what we were investigating. So we notified them of the police criminal investigation. Following on from that, we then sent information saying we would like access to or information in relation to these things, and Craig would then facilitate that.
And was every request facilitated?
Yes.
So every single thing you asked for of Mr. Harland you received?
So with the exception of some phones.
Right.
So we wanted some access to phones used by some media people within the DPP.
Mm-hmm.
There was no legislative provision
Mm-hmm.
for the New South Wales Police to demand those phones, so it had to be by consent.
Mm-hmm.
The DPP then had those phones reviewed internally, and we were told that there was nothing of interest on those particular devices.
Okay. I'm a little confused because I think you said that Craig Harland was your point of contact and that he facilitated what you needed, but I believe that you said that Craig Harland was your conduit to Sally Dowling and you'd
He was.
requested a statement from her and that wasn't provided?
So yeah, we emailed Mr. Harland requesting a statement.
Yes.
We then received correspondence back
Yes.
saying that that a statement would not be provided.
And what was the reason given for not providing a statement?
There wasn't a reason provided.
Okay. And was there anybody else that you requested a statement from?
No. We requested an interview then, so
Right.
if we move on to
Yes.
as part of the investigative process,
Yes.
and this isn't occurring in chronological order, but
Yeah.
in terms of there was then a media officer that we wanted to interview,
Yes.
and at that particular point we formed a view that we would do that interview under caution.
Okay.
That person engaged counsel, legal counsel, as their right. Then we received correspondence back from their legal counsel to say that they were not going to participate in a police interview, which is normal.
Would you be able to? We're aware of two media officers, one a junior one at level 5, a more senior one at level 7. Would you be able to indicate which of those media officers to whom you're referring?
The senior
The senior. Thank
media
you.
officer.
Thank you.
The junior officer did provide a statement.
Right. Would it be appropriate to provide this committee with a copy of the junior officer's statement?
I can. It was provided for the purposes of the investigation, so I think it might be wise to at least inform her that it's going to be distributed to the committee for this purpose, because it does contain personal information.
Yes. Yeah.
But,
I mean, I think we'd be happy to have the personal information redacted. Yeah. So you requested a statement from Ms. Dowling, the senior media officer, and you were able to interview and obtain a statement from the junior media officer?
correct.
And was there anybody else that you thought it would have been helpful to speak to about this matter?
Certainly 2GB.
Yep.
So we made an approach to them. Once again, they're not obliged to cooperate, but at least we wanted to ask the question. So we did that, and then we received correspondence back from their counsel, legal counsel, to say that they wouldn't be providing information to the New South Wales Police.
Yeah. We've received statements indicating that the Office of the DPP was initially cooperative with your inquiries, and then the tone changed and they became less cooperative. Is that a fair statement, or you have a different view? Look,
I have a different view. I wouldn't categorise it that way. The DPP were clinical in the way that they went about answering our requests. The information that they had, they provided. Where they were obliged to, for instance, with the phones, we would have liked the phones, but they're not obliged, and we can't compel them to provide the phones at that particular for a number of legislative reasons. So, in my view, we received the information we needed from the DPP.
I understand that you proposed to conduct an interview, and as you said, under caution. We have also received evidence that no offence was committed. Is that a statement that's able to be made based on your inquiries?
So when we offer an interview at that particular point, we were still gathering evidence, and that's trying to determine a point of truth. So when we look at that particular point, and it's important to make that distinction that it is under caution, we then, at a later point in time, determine, after receiving legal advice, that we weren't able to prove to the requisite criminal standard a breach of the law.
Is that the determination that was made?
Yes, it was.
And was that determination made because you had all the evidence available to you, or because on the evidence that was available to you, you couldn't prove it to the requisite criminal standard?
So the evidence that we were able to gather was put together, and it was summarised and it was assessed by the New South Wales Police legal team and the Operational Legal Advice Unit, and they determined, based on what we're able to, what was admissible, we weren't able to prove that a criminal offence had been committed.
Is it reasonable to believe that had additional or different evidence been available to you, that there may have been a different conclusion to your investigation?
It's difficult to say. For instance, if we had the power to execute search warrants, look at emails, it may have changed the outcome, but it's hard to answer because you're guessing, because you don't know what other evidence is gathered as a consequence of, the more information we have, the better we're able to determine a point of truth. But we can only act within the law and gather information lawfully, and where we weren't able to do that, unfortunately the investigation wasn't able to progress.
I've got more questions, but I'm conscious
Yeah,
that
I've
I've...
got a few.
Yeah.
Thanks, officer, for coming along. How many times in your career as a police officer has a prosecutor refused to provide a statement upon a request from you?
In my personal experience, I've never. It's probably the first time that it's ever been asked, and hasn't been provided.
Okay. In the course of the inquiry, we've taken evidence about a meeting in the DPP that involved the DPP herself, a media officer, an external media advisor, and perhaps another person, where the media officer believed that she got approval to provide this particular story to 2GB. And that's the meeting that seems to have led to the provision of the screenshot that I understand that you investigated. The judge who made the complaint that ultimately found its way to you says in her statement to us that she asked the chief judge to ask the DPP if the DPP had been responsible for the planting of that story with 2GB. And my question to you is, did you ever approach the chief judge to find out what she might have had to say about that matter?
No, we didn't.
No. And do you have any notes from the meeting that apparently occurred at the DPP where they talked about the provision of this story to 2GB?
No, we weren't provided with those.
Right, okay. Were you aware of that meeting?
That was all part. Yeah, we were aware of it, and that was part of the reason why we requested a statement.
Yeah. Okay.
Because then, once you're in receipt of that statement, you review it, and then then that identifies further avenues of investigation or other witnesses that may be relevant.
Yeah. Okay. Did you ever come into possession of information during the investigation that was relevant to the question of whether the DPP in that meeting had authorised the provision of the story to 2GB?
No.
So is that because you couldn't get a statement from the DPP herself?
That's right. The information we were receiving was probably third, fourth hand, perhaps, and it was really we need to focus on what's evidentiary and what we can prove.
Yeah. Did you get a statement from Sally Coloran, who was another media officer there? The senior media officer?
No, I mentioned before that particular individual was approached to see whether they would participate in a criminal police interview under caution, which is a different process to a witness statement. We need to be very clear about that they're entirely different.
Okay. In the judge's statement to us, her submission to us, she quotes you as referring to the junior media officer as a brave young woman. Are you
Yes.
able to explain why you called her a brave young woman, if you did?
Sure, look, that's a personal view. But here we have a young lady who's new to the role, new to the job. She provided a statement to the police. And the statement did discuss activities within the DPP at the time and her senior media officer, her direct supervisor. And she did that. And I just thought, you know, that to me was a brave thing to do when she didn't have to provide that statement. And she did receive legal counsel, which once again is common and appropriate. But she did provide us with a statement which did further the investigation in terms of establishing, you know, a point of truth.
So did you think that she was brave because she provided a statement in circumstances where her senior media officer and her ultimate employer had declined to do it, but notwithstanding that, she was willing to do it?
Well, at that particular point in time, I don't believe we'd approached Sally Dowling for a statement. So we need to be just in terms of the timeline, because that happened towards the end of the investigation. But
your conversation with the judge happened afterwards, didn't it?
That's correct.
Yeah, and that's when you expressed the view about her being a brave young woman?
Yeah, that's correct.
Because that was in the conversation where you reported to the judge that you couldn't progress further with the investigation because, in part, of a lack of cooperation.
The admissible evidence that we were able to collect wasn't sufficient to substantiate the charges.
Yeah. So when I was a young prosecutor, I was involved in the investigation of an offence that was alleged to have occurred in the precincts of the ACT court. And I sought advice from my supervisor about whether I should provide a statement. And my supervisor said to me, "You're a prosecutor and an officer of the court. Of course you should assist the police." Is that an opinion that you would tend to agree with generally?
It's difficult to say. Like, we deal with all walks of life in the police. Some provide statements and some don't. And whether you talk about right across the spectrum, it's not always clear that those who hold professional positions and jobs will cooperate with the police as compared to others who, you know, may mow lawns, for instance. It's different, and you can never pick it.
True, but we're talking here about...
As a police officer, as a general rule, I would like everybody to cooperate with us, particularly where we're investigating a criminal matter.
Yeah.
But that's a personal choice, and we cannot force them, but we do encourage them, strongly encourage them. But that's the best that we can do.
I'll put it this way. Were you surprised that the Chief Prosecutor in the state of New South Wales declined to provide you with a statement upon request in relation to the investigation of the potential breach of the child identity provisions?
I'd have to say, honestly, no, I wasn't surprised, because it's a choice that's available. They don't have to, witnesses do not have to provide a statement to the police, and it's not unusual. So I just need to make sure that it's very clear that members of the public do make this choice every single day.
Yeah. So in relation to your investigation of the possible breach of Section 62 of the Privacy and Personal Information Act, are you able to give us a sense of why you thought that there wasn't a prima facie case in relation to that offence? And I note that its elements are that a public sector official must not, otherwise than in connection with the lawful exercise of his or her official functions, intentionally disclose or use any personal information about another person to which the official has or had access to in the exercise of his or her official functions. Was your concern that the actions in providing the information was authorised, or you couldn't prove that it wasn't authorised? Or was your concern about whether you could prove an intentional disclosure, or was there some other concern that you had?
So look, when we look at why the matter didn't proceed, we were simply not able to gather sufficient evidence, admissible evidence, to meet the criminal standard for any of those particular offences. There was issue with being able to prove, whether something was published or broadcast, under the
That's
Criminal
about
Proceedings
15A,
Act.
I understand
Yep,
that.
that's 15A.
But in terms of this one, you had the screenshot, correct? And
Yep.
you could prove who'd provided the screenshot.
No.
So what was the problem fundamentally?
We were missing that element of what we could not prove who provided that screenshot.
You couldn't.
We couldn't.
Yeah. And you couldn't
Nor,
prove.
or the medium that it was provided.
Yeah. And could you also not prove whether the provision of the information was authorised or not?
Correct. That would have been one aspect of it.
Yeah. And that's a matter that obviously pertained to the meeting where Miss Dowling, the senior media officer, and the external advisor were at.
It may have. I wasn't present for that, and it relates also to what was and wasn't approved in terms of policy. What we couldn't exclude that it wasn't in relation to the exercise of the media officer's normal duties. As a media officer, they would have contact with journalists all the time, I would assume. Certainly our media officers do. It's an important key relationship, so I assume it would operate the same way at the DPP. I don't know that.
So those were matters that the DPP herself may well have possessed highly pertinent information in relation to, correct?
I can't speak for Ma'am Dowling. I'm sorry. I
No,
don't
that's
know.
the reason why you asked her for a statement, I assume.
Essentially, there was a range of things that we just a general sense of, what she knew, the fact that she was the DPP, the structure of the DPP, the role of the media unit.
You thought she may well have had highly pertinent information, correct?
It would have assisted us to identify further lines of investigation.
You thought that she may have had highly pertinent information.
Yes.
Yeah. And she refused to give you that information.
Well,
assuming it
the
existed.
request was made and it was declined.
Yeah. And that meant effectively that you couldn't progress your investigation as far as you wanted to.
True, but that wasn't probably the nail in the coffin. There were a number of issues in relation to it.
So what were the other nails in the coffin, can I ask?
Well, if we look at it, the particular sections we're talking about, in 2026, they're always going to be committed using, for instance, an electronic device of some description.
Right, and you couldn't get the phone.
The medium that it would be transmitted, whether that's cellular, internet-based, that all adds to the information that we would like to gather. Now, in particular, the offences that we were looking at are not searchable offences under LEPRA, so we are not able to obtain search warrants for those. So one of the very first things we would have done, had we been had the legislative ability to do so, was probably execute search warrants and secure the electronic evidence, and we weren't able to do that. And there was also some legal advice we received in relation to journalism type warrants and our ability to be able to obtain one of those.
Yeah. Just in conclusion, we took some evidence last year from Sally Dowling that she'd only become aware 2 days before the hearing where she gave evidence that the DPP, as in the organisation, had been the source for the story that was given to 2GB. Now, did you say before that in the course of your investigation you became aware that the DPP had provided the story to 2GB?
So that was an assumption that we were running on right from the beginning because of the nature of once the Shadow Attorney General provided us with information, we were able to see the screen and essentially work backwards, and we thought that the source was from a DPP IT system.
Yeah. So do you have any evidence that you gathered in the investigation that's relevant to this question of whether Miss Dowling could have been unaware until late last year that her organisation had actually been the source of the story?
As part of the investigation, I'm not aware of any of my investigators, and I certainly didn't. We never had direct contact with Sally Dowling. We were dealing with Craig Hyland, and he would facilitate requests for information, and it was through Craig. We emailed a request through Craig Hyland for a statement, and then we received a response.
Yeah. And the statement you got from the judge, it contained information in paragraph 13, which said, "I've been told by the Chief Judge of the District Court, Justice Sarah Huggett, that after the broadcast, she spoke to the Director of Public Prosecutions, Ms Sally Dowling SC, who denied disclosing the identity of the young person to 2GB or providing any information about the case to the radio station."
Mm-hmm.
That's obviously in 2024. So that doesn't twig your memory in terms of whether you got any information in your investigation that would be relevant to this question of when Miss Dowling would have turned her mind to whether her organisation had actually been the source of the story, had planted the story?
Not that I can recall. As I said, it would come down to when we would make a request to Craig Hyland, and particularly the initial request, which I think was on the 25th of the 11th, 24.
Yeah.
That was the first time we formally had written to the DPP through Craig Hyland and indicated what we were doing and had a list of information that we would like. So it's at that point there where you'd have to probably speak to Mr Hyland as to what conversations he had. But I certainly can't. I never spoke to Ma'am Dowling, so I'm not able to assist you there.
So were you aware during your investigation, and I ask this because it would maybe go to motive, were you aware that there had been this dispute between Judge Wass and the DPP in relation to the prosecution of sexual assault matters, things that Judge Wass had said in judgments, some sort of acrimony between the two?
I wasn't aware of it prior to meeting Judge Wass. I certainly became more attuned to it once this investigation started.
And in light of all of that, was the DPP a suspect in terms of maybe having played a role in the provision of this information in potential breach of the law? Was that something that was on your mind at some point during the investigation?
Right at the beginning, it wasn't clear, but there were suspicions. But once we received the screenshot from the Shadow Attorney General, that confirmed that the DPP were a relevant line of investigation.
Yeah. So
for us.
So she was a suspect.
Sorry,
She was a suspect.
She, me.
She, the DPP.
Well, the DPP's a very big office. I don't think I wouldn't have categorised Ma'am Dowling as a suspect. My point would have been that it's within the DPP.
The organisation.
The organisation. There was certainly no evidence that we gathered that Ma'am Dowling had certainly been involved in sending that particular screenshot on. And in fact, once the investigation progressed, we gathered further information that confirmed that.
Yeah, that confirmed what?
That the screenshot is unlikely to have been sent. We weren't able to establish who sent it, but it was more likely to be sent by one particular individual than it was members of the senior members of the DPP.
Yeah. Okay. Okay. Thank you.
All right.
Thanks, Chair.
No more questions?
I've just got a couple of questions, but only when it's appropriate, Chair, sorry.
Yeah, we're going over time now, so.
I've got two quick questions, if that's okay. The first one goes, following up on the questions from my colleague, the Honourable Stephen Lawrence, in relation to authorisation of publication. Did your investigation look at the DPP prosecution guidelines and their express prohibition on publication of information in relation to children?
Well, that's a legislative provision, so it applies to everybody. And that
No, sorry.
Sorry.
The prosecution guidelines, the internal manual that they have for how they conduct their business in the DPP specifically addresses the fact that nobody in that office is to release information in relation to children. Did you consider that as part of your investigation into authorisation of release of information?
Look, at this point in time, it wasn't considered relevant. An internal policy document wasn't considered as relevant as the applicable legislation at the time that governs that.
Sure. And you indicated that you couldn't execute search warrants because of the provisions of LEPRA. Is it your view that in order to be able to properly investigate matters of this nature, it would be useful to have greater powers for search warrants? So changes to LEPRA?
Well, that's my personal view, and as the commander of the cybercrime squad, I can say a lot of our legislation hasn't kept up with modern technology. When we talk about data at rest, and so it would help, certainly in this case. But that's a matter, and it's certainly something that we have raised as part of our review of this particular matter. That I think it's something that's worthwhile us putting forward later on this year with a number of amendments that are all cyber related. We'll include that for consideration.
Are you able to share a copy of your review of the investigation with this committee?
I can take that on notice.
Thank you.
It's an internal document.
Thank you.
Sue?
Thank you, officer. I apologise for appearing online. It was just difficult to be there in person today. Thank you. I was just wondering if you could tell me whether. So, I think your evidence. Did you contact 2GB about the disclosure?
Yes.
And can you remind me? I don't know if you said this at the beginning, but what was that response?
So we, as part of the investigation, obviously we were keen to engage with 2GB to get access to their business records. So what we did in that particular case was corresponded with them, and they engaged counsel, and counsel then wrote back to us and said that they weren't going to assist.
And then with your interactions with Mr. Hyland as the appointed person of contact at the DPP, was he provided a copy of the screenshot that you had been provided with early on in your interactions with him?
I believe he was. That was done by Detective Sergeant Julian Thornton, but I believe he was, so that we could. Matters is not something New South Wales Police has access to, and I must admit before this I'd never heard of Matters. We'd use a different system, so we wanted to confirm that was a DPP system, which Mr. Hyland was able to certainly confirm for us.
Thank you. And did Mr. Hyland at any time give you or any of your officers any preliminary explanation about that screenshot and how it may have ended up in the hands of 2GB?
No, I don't believe he did.
Was there at any point any discussion with him about that? I.e., was there any discussion with him about here's the screenshot? How do you think it may have landed in the hands of the 2GB?
No, there was some discussions with Mr. Hyland about, the structure of the media officers, who they are, how they work, within the organisation. Certainly, what accesses they had. Did they have access to Matters? For instance, that was something that we were keen to understand. So he was able to confirm information like that for us.
And was Mr. Hyland, in your view, and any dealings with him, was he, would you say, highly concerned, moderately concerned, or just very, not concerned, or trying to think of a better word, not concerned, obviously, or just expressionless about what was happening?
I describe my interactions with Mr. Hyland as just professional. He's a lawyer, and I've always found him just professional. So in terms of expressing concern about particular behaviour, if he had concerns, he certainly didn't express them to me, because his concerns aren't evidence. So at that point, when I'm engaging with Mr. Hyland, I'm looking to gather evidence. What he thinks about the actions or the alleged actions is, that's not evidence, so it doesn't really formulate. But I found him professional.
So then, was there anybody in your dealings with anyone whom you spoke with at the office of the DPP? Was there anyone that expressed concern about the fact that an identity of a young person had been, for what disclosed on the broadcast?
Well, certainly the junior media officer, as part of her statement, you can tell by the content of that statement that she had reservations or was certainly considering the appropriateness of that. But in my discussions with the DPP, there was nobody that was expressing concerns, but we weren't asking those types of questions at that particular time, because we were also trying, there's no point going into the DPP and publicly broadcasting that we're investigating things, because at that point when we're approaching Mr. Hyland, we do that in a confidential nature. He's a senior solicitor within the DPP. He's a point of contact that the police have used for some time. As I said, it's not the first time I've engaged Mr. Hyland. I've never met him. I've only ever had Teams meetings and phone calls and emails with him, but their level of concern at that particular time, it just wasn't relevant to our investigation, to a criminal investigation. It's probably more to a departmental.
Thank you. And just finally, given the what we now know, and that is we've heard evidence that or we're aware of, that there is the identity of a young person who has been disclosed, and that may well lead to detrimental impacts in his community, because it's a small regional community, so forth. Is there anything that you could say or suggest in terms of the law, through the investigative process that you engage with, that we as a committee would or should consider in terms of better providing the protection that I think the legislation originally intended to provide for young people?
So look, I think I've already mentioned in terms of having some of these offences subject to searchable offences under LEPRA, but also we also need to consider that the communication of this information may not necessarily just be done via a phone, a text or email. Social media plays a part. So it probably needs to be more explicit in that respect, in terms of what you can and can't do, and how the impacts of social media, because that's highly unregulated, and once something's out in social media, it's very, very difficult to have that information removed, so it doesn't impact on the young person. I completely understand why the provisions are there, and I support it, but once it's out and we're trying to turn the clock back, it's very, very difficult.
Thank you, Chair. Thank you.
Okay. Any more questions? No more questions? Thank you very much. Thanks very much for coming.
Thank you, Chair.
Thank you. Superintendent.
Thank you very much.
Craft. I'm told you took some questions on notice. The Secretariat will be in contact with you. Thank you very much.